And so with that, I'm going to welcome up Judge Amal Thapar from the Sixth Circuit, and he's going to introduce our panelists.
Thank you very much for having us. While they're getting seated, I do want to make sure I wish my colleague, Judge John Nalbandian, as well as Luann Reuter, happy birthday. It's both their birthdays today. So happy birthday. It's John's 75th, in case you see it. We also, all of us, and I'm just going to do it for all of us, want to thank Arizona State, their local Federalist Society chapter, and the Dean for putting on such a great event. And we want to thank the Federalist Society for putting together such a fabulous panel of diverse viewpoints. You won't see this level of diversity of viewpoint anywhere else. As you all know, the debate around the Privileges or Immunities Clause is fascinating. And so we want to get to it. I'm going to give brief introductions so we can get on time. This is probably Professor Epstein, which none of us are, because if you noticed, he did his whole speech without any notes, which is pretty amazing. First, Professor Zitlow. There's some really great facts about her I want to tell you. First, she used to live in Toledo, the greatest city in the world. Yes, the city I was raised in. But the better fact, and maybe one of the coolest facts, is that when the other three panelists were asked who would be a good fourth panelist, individually and unanimously, they picked her. That says something tremendous about her. She's also got a book called Enforcing Equality, Congress, the Constitution, and the Protection of Individual Rights, which studies the history of congressional protection of rights and the implications of that history for constitutional theory. My good friend, Professor Barnett, will go second. I always like to say in my speeches about originalism that he's the professor that made originalism cool. I recently read one of his newest books, Our Republican Constitution, Securing the Liberty and Sovereignty of We the People, which all of you should read, and it's one of his 12 books. And he runs the best seminar on originalism. It's a one-week seminar at Georgetown. Unfortunately for all of you, it's already full this year, but I encourage you to apply next year. It is competitive, but what he told me tonight is if you don't get in, he makes the videos of it available to you. So I highly encourage everyone to apply. One final fact about him, which I think is pretty cool, he argued Gonzalez v. Raich in the Supreme Court. The next professor is Professor Kurt Lash. He will go third. He's currently working on the Reconstruction Amendment's Essential Documents, which is 2 volumes. He told me about it tonight. It's in its final printing at the University of Chicago. I'm sure Professor Epstein has skewered it before he will let it go out, but we're hoping it will be out soon. It's going to be a must-have for judges, students, and academics alike, and will be a fantastic contribution to the profession. He's published a number of other books, as well as one about our topic today. Elon's going to hold it up. There it is. Another great fact about that, if you like this debate, Professor Lash and Professor Barnett are having the same debate in print. It'll be coming out in the Notre Dame Law Review. And as part of the reward for being the moderator, I got a sneak preview of them. And they're fabulous, and you should definitely read them. I definitely got smarter by doing so. Last but not least is Professor Elon Werman, who's a friend of mine and one of the best young professors, if not the best young professors in the country. He is on his home turf here at Arizona State, and and I admire all the dean's done, but I definitely admire that he hired Professor Werman. He wrote a little book about originalism known as Debt Against the Living, which is a must-read for all of you. And I have to say, so I don't get in trouble, that he clerked for Judge Jerry Smith, because Judge Smith will call me if I don't mention that. So finally, to be on this panel, we can conclude 3 things. You have to be highly sought after, you have to be brilliant, and you have to be a great author. Since I'm none of those, I get to be your moderator. Professor Zitler.
Thank you so much, Judge, and it's really great to meet you today and to learn about your Toledo roots. Today I'm going to be talking about the significance of citizenship rights to the anti-slavery movement. Excuse me. Central to the citizenship rights were central to the ideology of the political anti-slavery movement and the doctrine of anti-slavery constitutionalism. Oh, okay, okay, sure. Anti-slavery constitutionalists were activists, journalists, and lawyers who were involved in the political anti-slavery movement. They brought some lawsuits, but they primarily made their arguments in political terms in the court of public opinion, and they were involved in forming the Liberty Party, the Free Soil Party, and eventually the Republican Party. They developed an anti-slavery ideology that influenced the Republican Party and the leaders of the Reconstruction Congress, including, I'd be remiss if I did not mention the subject of my most recent book, The Forgotten Emancipator, James Mitchell Ashley and the Ideological Origins of Reconstruction. So if you're interested in these guys that I'm talking about, I don't have my book right here, but it is available, and I'd love to have you read it. Now, anti-slavery constitutionalists argued that citizenship rights came from several sources, including the structure of the government itself, the Constitution, especially the Article 4, Privileges and Immunities Clause, and natural rights, including fundamental human rights. They focused, when they talked about citizenship rights, primarily on the rights of free blacks, but they also argued that freed slaves would be entitled to the rights of U.S. citizens. Some northern states recognized free blacks as state citizens with the right to be treated as such when they traveled to other states. Others advocated a doctrine of national citizenship that would protect free blacks throughout the country. For example, anti-slavery journalist Lysander Spooner argued that if states abolished slavery, slaves would immediately become U.S. citizens. Spooner championed the concept of a full and equal national citizenship. Others, including the notable lawyer and anti-slavery activist Joel Tiffany, argued that enslaved people were also citizens. That is, you didn't need to be free to be a citizen, that everyone who was born in the United States, including slaves, had the rights of citizenship, including the right to be free. Tiffany argued that all persons born within the jurisdiction of the United States since the adoption of the federal Constitution became citizens by birth. The Supreme Court, of course, rejected that argument in the Dred Scott decision, which Professor Epstein was describing to us moments ago. But by 1866, leaders of the Reconstruction Congress, including John Bingham and William Fessenden, members of the Joint Committee on Reconstruction and influential members that we'll probably be hearing more about in a bit, believed that former slaves were U.S. citizens and entitled to the rights of citizenship. With the 1866 Civil Rights Act and the 14th Amendment, they embedded Tiffany's theory of birthright citizenship into U.S. law. So what were the rights of citizenship? What do these people think that the rights of citizenship were? Well, first and foremost, citizenship meant belonging, being a member of the polity, including the freedom to travel. Slaves were denied the freedom to travel, of course. Their mobility was entirely restricted. The freedom to travel, however, was also important to free blacks who risked being kidnapped and enslaved, not only when traveling in slave states, but also while at home, by slave catchers purporting to recover fugitive slaves. In addition, some northern states, such as Illinois and Indiana, prohibited free blacks from entering, hindering their mobility as well. Laws and policies restricting travel sent the message that slaves and free blacks did not belong in our country. Anti-slavery activists argued that free blacks had the right to travel. For example, in the early 1840s, congressional debates over the Seamen's Acts, which were acts that were passed by the state of South Carolina, that authorized the arrest and enslavement of free sailors, black sailors that landed in the ports of South Carolina. the Massachusetts representatives in Congress argued that free black sailors from Massachusetts were citizens, and the Seamen's Acts violated their citizenship rights. Fugitive slaves also asserted the right to travel when they escaped bondage and fled into free states. And activists in the free states, including members of the Underground Railroad, enabled their escape. Northern states enacted personal liberty laws to protect people who were accused of being fugitive slaves, including giving them due process rights to defend themselves in court, and sometimes authorizing the arrest of slave catchers for kidnapping. And these laws also recognize the right to travel of free blacks and fugitive slaves. Another act of belonging recognized as a right of citizenship was the right to participate in the government, including the right to appear in court, to file petition for redress, serve on a jury, enter into legally sanctioned contracts. John Bingham famously argued in 1858 that these were rights of citizenship that were being denied by the proposed Constitution of the Territory of Oregon that was trying to become a state. The right to citizenships also included the right to protection by the government. In 1836, anti-slavery activist Theodore Dwight Weld argued that protection is the constitutional right of every human being under the exclusive legislation of Congress. Well, Well's contemporary James Birney agreed that the slave's duty to obey the law entitled them to the protection of the government. For example, the right to travel would be meaningless unless travelers could count on state protection against attacks and kidnapping. Another right of citizenship was equality and the fundamental human rights. Some argued that the rights of citizenship were broader, encompassing all the fundamental human rights. They argued that citizenship rights came from natural law and could not be taken away by governments. They cited the well-known 1823 case of Corfield versus Coriel to support their broad natural rights view. In Coriel, Justice Bushrod Washington, writing circuit, defined the rights of citizenship broadly as the right to, including the right to protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety. Here, Justice Washington invoked the concept of natural rights, the rights of citizenship being equivalent to fundamental human rights. Some anti-slavery activists argued that among the right to pursue and obtain happiness was the right to be treated equally, free of race discrimination. They opposed Northern black codes, which discriminated against blacks and limited their rights, and some succeeded in overturning those laws. Finally, the right to citizenship also included the right to free labor, the right to work free of undue coercion for a living wage and free of discrimination. Anti-slavery activists repeatedly invoked the right to free labor, the right to the fruit of one's labor, which was enforced by the 13th Amendment, which abolished not only slavery and involuntary servitude, and also by the 1866 Civil Rights Act and other Reconstruction-era statutes. So, along with the theories that were voiced by the anti-slavery constitutionalists, on the ground, activists also asserted their rights, slaves and free blacks advocating for citizenship rights. During the antebellum era, fugitive slaves risked their lives to escape to freedom. They asserted their right to travel and sought protection when they reached free states. They also raised crucially important questions about citizenship. Were they citizens of either a state or the federal government? Could they be citizens? Were they entitled to the protection of the government of free states? Or were the free states bound by the Constitution to assist slave catchers in returning them to captivity? By and large, the courts ruled, and Congress passed Fugitive Slaves Act that took the latter position, that the free states were required to return fugitive slaves and that they did not have the right to become free when they entered free territories. But disputes over fugitive slaves caused tension between free and slave states. In 1850, Congress enacted the 1850 Fugitive Slave Act, which authorized the appointment of federal magistrates in northern states because some northern state officials refused to cooperate with slave catchers. Thus, fugitive slaves also raised issues of federalism. To what extent did state authorities have the power to resist federal law? Free blacks in the North responded to fugitive slaves with their own activism. Underground Railroad assisting fugitive slaves in their escape to slavery, activists responding more publicly as well, storming courtrooms, staging public protests when people in their community were caught and accused of being slaves. A notable example from my state of Ohio were the town officials and community members of Oberlin, Ohio, who rescued a man who was kidnapped by slave catchers, and some were prosecuted for violating the Federal Fugitive Slave Act. Many of the participants in the Underground Railroad and the demonstrations were free blacks. And in large cities in northern states such as Chicago and Philadelphia, free black communities openly defied slave catchers, hid fugitives, and made it impossible for the slave catchers to function. Disputes over the status of fugitive slaves exacerbated the tension between slave and free states, which culminated in the Civil War. And during the Civil War, free blacks also asserted their citizenship rights or their status as citizenship by volunteering to serve in the Union Army. Fighting for one's country is an obligation of citizenship and the ultimate expression of belonging. In addition, slaves crossed enemy lines, went over to the north, and when they were freed, they also volunteered to fight for the Union. And members of the Reconstruction Congress cited their sacrifices on the battlefield to justify constitutional amendments and statutes protecting their rights, arguing that those sacrifices entitled them to be recognized as citizens and to the protection of their rights by the federal government. After the war, freed slaves left plantations asserting their citizenship rights. They rejected the imposition of contracts with their former masters, demanded the right to free labor. They also demanded the right to vote. The right to vote was controversial in the Reconstruction Congress, where it had been considered to be a political right and not a right of citizenship. But freed slaves insisted that they would not be equal citizens unless they had the right to participate in the formation of the government. When the Reconstruction troops protected the right of freed slaves to vote, they voted. And with their vote, they shaped the Reconstruction measures and elected some freed slaves to Congress. Just one more word on one of those measures, the 1866 Civil Rights Act, directed at dismantling the Southern Black Codes, which sought to impose involuntary servitude on newly freed slaves. The 1866 Civil Rights Act had a citizenship clause similar to that of the 14th Amendment, establishing birthright citizenship and linking rights to citizenship. In the Dred Scott decision, Supreme Court had held that persons of African descent could not be citizens. So where did Congress's power to recognize freed slaves come from, as citizens come from? Either members of the Reconstruction Congress believed that they could overturn the Supreme Court interpretations of the Constitution, which is interesting in and of itself, or they believed that the 13th Amendment gave them the power to do this. To be free meant to be a citizen, to belong, and to enjoy the rights of citizenship. Thank you.
Well, I want to begin by congratulating the Arizona State Federalists for putting this amazing program together. You deserve a lot of praise for this. I was going to compliment you and congratulate you on keeping Richard within the appointed time limit. You almost got there, not quite, almost. Presenting the evidence needed to establish the original meaning of the Privileges or Immunities Clause in just 12 minutes is impossible. So I'm going to ask you to focus on just 3 primary data points, and you're going to see it's going to pick up in many respects where Rebecca left off. The 3 data points are this. First, Justice Bushrod Washington's explanation of the meaning of privileges and immunities in the case of Corfield versus Coryell. Second, the wording of the Civil Rights Act of 1866. And third, Michigan Senator Jacob Howard's speech explaining the clause to the Senate. Any theory of the Privileges or Immunities Clause and its original meaning that cannot comfortably accommodate these 3 items is highly questionable. So let's take data point number 1. The Privileges and Immunities Clause of Article 4, Section 2 provides that, quote, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. This clause protected the rights of citizens of one state when traveling in another state. While it was generally taken by courts to bar discrimination against out-of-staters, anti-slavery activists insisted that it guaranteed to every American citizen the protection of a set of fundamental rights when traveling in another state. You've just heard about this. For example, the imprisonment of free black sailors from northern states by Southern authorities while in Southern ports became a cause célèbre in the North. Northerners protested this denial of privileges and immunities under Article 4, despite the Southerners' claim that they were treating out-of-state blacks in the same manner as they treated their own free blacks, and hence were not discriminating against them. For the Northerners, the issue was not how a state treated its own citizens, but whether a fundamental right was being denied to an out-of-state citizen. But what were the fundamental rights to which all citizens were, in the words of Article 4, entitled? In 1823, Justice Bushrod Washington, George Washington's nephew, was called upon as a circuit judge to address the scope of the rights protected by Article 4. The inquiry, he began, what are the privileges and immunities of citizens in the several states? He then explained, quote, "We feel no hesitation in confining these expressions to those privileges and immunities which are in their nature fundamental and which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this Union from the time of their becoming free, independent, and sovereign. What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, be all comprehended under the following general heads: protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject, nevertheless, to such restraints as the government may justly prescribe for the general good of the whole." Justice Washington then proceeded to list some examples, which in the interest of time I'm going to have to skip. But in the core of what I've read, Justice Washington is repeating nearly verbatim the canonical formulation of natural rights that was penned by George Mason for the Virginia Declaration of Rights, and which was then replicated in 4 state constitutions. Here's what Mason wrote: "That all men are born equally free and independent, and have certain inherent natural rights, of which they cannot by any compact deprive or divest their posterity, among which are the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety," the very same words that Justice Washington used. It was upon this language in the Massachusetts Constitution that the Massachusetts Supreme Judicial Court had based its ruling in 1783 that slavery was unconstitutional in that state. So that language was pretty important. That's data point number 1, Corfield versus Coryell. Data point number 2. On April 9th, 1866, Congress passed, and this is the official title of the act, an act to protect all persons in the United States in their civil rights and furnish the means of their vindication. Known as the Civil Rights Act of 1866, the act was passed pursuant to Congress's enumerated power to enforce the 13th Amendment's ban on involuntary servitude. It began by declaring, quote, "that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States." It then proceeded to guarantee that all such persons, quote, "shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefits of all laws and proceedings for the security of persons and property as is enjoyed by white citizens. Any law, statute, ordinance, regulation, or custom to the contrary notwithstanding." After passage, President Andrew Johnson vetoed the bill as beyond the power of Congress to enact under the 13th Amendment. Congress responded by overriding the veto with a supermajority vote. But some members were concerned about whether such a measure really was within congressional power. Others had a different concern. What would happen to this statutory guarantee once the Democrats from the southern states resumed their seats in Congress? As Democrats were loudly proclaiming it was their intent to repeal the bill as soon as they got the chance, Who could say if they might one day have the votes to do so? In addition, what would the court say about Congress trying to reverse by a mere statute the Supreme Court's decision in Dred Scott, denying that descendants of African slaves could ever be citizens of the United States? For all these reasons, many in Congress supported a parallel effort to adopt a constitutional amendment to make the freedmen U.S. citizens and to protect the fundamental rights of all U.S. citizens from being abridged by state governments, as Southern states were then doing, both to freed blacks and to white Republicans in the South. Which brings me to data point number 3, the 14th Amendment. 6 weeks later, on May 23, 1868, Jacob Howard from Michigan, Senator Jacob Howard from Michigan, who was its former Attorney General, introduced the 14th Amendment in the Senate as its designated sponsor. On that day, he delivered a comprehensive and widely reported address in which he explained the meaning of the amendment, beginning with the Privileges and Immunities Clause, which he described in his speech as, quote, very important, unquote. By this clause, he said, citizens of the United States, quote, are by constitutional right entitled to these privileges and immunities and may assert this right and these privileges and immunities and ask for their enforcement whenever they go within the limits of the several states of the Union. In other words, and this is me, not him now, no state shall abridge the fundamental rights of a citizen of the United States. But then, what are these fundamental rights? According to Howard, the privileges or immunities of U.S. citizens consisted of 2 categories of fundamental guarantees. That's his words, fundamental guarantees. In the first category were, quote, the privileges and immunities spoken of in the 2nd section of the 4th article of the Constitution. That's the Article 4, Privileges and Immunities Clause. Howard noted that he was, quote, not aware that the Supreme Court have ever undertaken to define either the nature or extent of the privileges and immunities this guaranteed. But we may gather some intimation of what probably will be the opinion of the judiciary by referring to a case adjudged many years ago in one of the circuit courts of the United States by Judge Washington. And I will trouble the Senate, but for a moment, by reading what that very learned and excellent judge says about these privileges and immunities of the citizens of each state in the several states. Howard then read a very lengthy passage from Justice Washington's opinion in Corfield, longer than I had time to read tonight, which included this language: protection by the government, the enjoyment of life and liberty, and the right to acquire and possess property of every kind and to pursue and obtain happiness and safety. I've already read that to you. In his handwritten notes for his Senate speech, Senator Howard described all these Corfield privileges and immunities as, quote, fundamental civil rights. But Howard was not yet finished. He then located a second, additional category of fundamental rights. Quote, to these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their extent and precise nature, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. After reading a list that included most of the rights listed in the first 8 amendments of the Constitution, Howard then summarized his understanding of the 2 categories of privileges or immunities. Quote, now, sir, here is a mass of privileges, immunities, and rights, some of them secured by the 2nd section of the 4th article of the Constitution, which I have recited, some by the first 8 amendments of the Constitution. It was a mass of privileges, immunities, and rights. It will become important as our discussion proceeds to note that he did not distinguish between these 2 categories of rights, privileging, say, the enumerated rights in the first 8 amendments at the expense of the Corfield rights. Instead, he described them all as a mass of privileges, immunities, and rights, to which the text of the Constitution already refers. Everybody's looking over here. What's going on over here? Nothing, huh? There's beeping. Okay, there's beeping. The beeping apparently is extremely attractive to most of the people in this room. Come on back. Come on back. Okay. All right. Howard then explained that a constitutional amendment was necessary to protect these rights because at present, quote, they did not operate in the slightest degree as a restraint or prohibition on state legislation. So, quote, "The great object of the first section of this amendment is to restrain the power of the states and compel them at all times to respect these fundamental guarantees." From these three data points, we may conclude the following, and I'm going to summarize this, basically use the language of all the three data points. I'm going to combine it into one running sentence. No state shall make or enforce any law which shall abridge those privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign, including the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, which includes the right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, sell, lease, hold, and convey real and personal property, as well as the personal guarantees, as well as the personal guarantees contained in the first 8 amendments. But before closing, I must add one more thing. The idea that this mass of privileges, immunities, and rights can be protected from abridgment by state governments, by Congress under Section 5, and by the federal courts may seem like a radical proposition. And there is no doubt that the 14th Amendment did alter the nature of our federalism by design. But it's not nearly as radical as it sounds. Recall that Justice Washington added that the enjoyment of life and liberty and the right to acquire and possess property of every kind and to pursue and obtain happiness and safety was subject, nevertheless, to such restraints as the government may justly prescribe for the general good of the whole. In other words, states have the just power to regulate the exercise of these rights, which is called the police power, provided that such regulations are actually adopted to serve an end to which legislatures are competent, and that's the word that they favored, competent, such as the protection of the health and safety of the public. As Justice Bradley explained in his dissenting opinion in the slaughterhouse cases, the, quote, "right of a state to regulate the conduct of its citizens is undoubtedly a very broad and extensive one, and not to be lightly restricted. But still, quote, there are certain fundamental rights which this right of regulation cannot infringe." And here is the distinction he then makes. "It may prescribe the manner of their exercise, but it cannot subvert the rights themselves. Manner of their exercise is regulation, subversion is violation and abridgment." Of course, there's much more to be said about the original meaning of the Privileges or Immunities Clause and how to implement that meaning today. But this is the best I can do in 12 minutes. I'm sure I will have more to add after you hear from my good friend, Kurt Lash.
Well, this is such a wonderful conference. It's a pleasure to be here. My thanks to the Federalist Society, for ASU, for putting this together, to Judge Thapar for moderating, and it's so wonderful to see my colleagues here on the panel and to be a part of this discussion. All right, Section 1 of the 14th Amendment. It accomplished, obviously, and all of us know this, it accomplished a remarkable transformation in American liberty, where once the Bill of Rights only bound the federal government, the 14th Amendment now made all of the rights enumerated in the 1791 amendments applicable and enforceable against the states. These were now the rights of national citizenship that no state could abridge. Section 1 also contains the due process and equal protection clauses, clauses which ensure that all persons receive the equal right not to be deprived of life, liberty, or property without the due process of law. These last two clauses of Section 1 authorize legislation like the 1866 Civil Rights Act, which, as repassed in 1870, gave all persons, not just citizens, all persons, the same right to make and enforce contracts and to fulfill the equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. Together, these three provisions establish truly national individual liberty for the first time in our nation's history. But just how this actually occurred, of course, is a matter under some dispute. The Privileges or Immunities Clause in particular has been debated and fought over for decades. Once dismissed as no different than a text obscured by an ink blot only a few decades ago, today's serious historical research conducted by every member of this panel has moved us to the point of being able to engage in a serious and historically grounded debate on the meaning of national privileges or immunities. And this is a very, very welcome development. Currently, I believe there are three basic readings of the Privileges or Immunities Clause. The fundamental rights reading, which you've heard something about, I think, from our first two panelists so far. The enumerated rights reading, which I'm going to talk about just briefly. And the equal rights reading, which Elon, I think, is going to discuss once he's up here. In my work, I have argued that the best reading of the historical record supports what I call the enumerated rights reading of the Privileges or Immunities Clause. And according to this view, the clause ensures that all constitutionally enumerated rights are protected against state abridgment. All non-constitutionally enumerated subjects, however, remain under the regulatory control of the people in the several states, subject only to the requirements of due process and equal protection. The enumerated rights understanding of the Privileges or Immunities Clause thus allows for a dramatic expansion of constitutional liberty over that established at the time of the founding, while at the same time maintaining the founding's basic structure of constitutional federalism. Now, scholars sometimes claim that the Republicans who drafted and ratified the 14th Amendment rejected constitutional federalism and sought to establish new principles of constitutional nationalism. This is false. Although some radical Republicans tried to abandon constitutional federalism, their efforts were repeatedly and successfully defeated by a coalition of conservative and moderate Republicans. To these Republicans, the principles of constitutional liberty and constitutional federalism were equally non-negotiable. At the center of this coalition was Ohio Representative John Bingham, the man who drafted the Privileges or Immunities Clause. Bingham insisted that Congress had but limited enumerated powers, and thus Congress needed an amendment, granting them power if they wished to enforce the Bill of Rights against the states. When radical Republicans tried to abandon constitutional federalism and simply establish their own federal control over civil rights in the states, Bingham rebuked them. "Sir," Bingham said, "I am not to be thus driven into a violation of the letter and spirit of the Constitution of the country. Under it, the rights of the states are as sacred as those of the nation. Its express provision is that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively, or to the people. The equality of the states and the equality of men in the rights of persons before the law is what the Constitution enjoins, and the people demand," end quote. Now, if I had come across that speech by John Bingham, praising the 10th Amendment and the rights of the states prior to my researching the history of the 14th Amendment, I would have been somewhat surprised. Like many scholars in my generation, I'd been taught that members of the Reconstruction Congress hated federalism and states' rights. This is why it was so obtuse of Justice Miller in the Slaughterhouse cases to insist on interpreting the 14th Amendment in a manner that preserved the principles of federalism. At least that's what I was taught. I now know that Justice Miller was absolutely right to refuse to read the Privileges or Immunities Clause as protecting unenumerated rights, and he was especially correct to point out that embracing the plaintiff's claim in Slaughterhouse, when combined with the powers granted to Congress under Section 5 of the 14th Amendment, would have radically undermined constitutional federalism, an outcome that neither Bingham nor the moderate Republicans nor the ratifying public desired, and certainly not what they understood to be the effect of the Privileges or Immunities Clause. What Bingham and the moderate Republicans desired was a constitution that finally applied the Bill of Rights against the states. For decades, Southern slave states had denied blacks their Fifth Amendment right not to be deprived of life, liberty, or property without due process of law, rights that Republicans insisted represented the natural rights of all persons, as originally announced in the Declaration of Independence. Not only had the slave states denied the basic natural rights of enslaved blacks, They consistently denied the First Amendment rights of all American citizens, white or black, to free speech, press, assembly, and the right to the free exercise of religion. Although people in the North increasingly looked upon these constitutional enumerated rights as the rights of citizens of the United States, neither the courts nor Congress had any power to demand that Southern states respect these rights. In Barron v. Baltimore, a case you probably studied, the Supreme Court refused to apply the Bill of Rights against the states because the provisions in the bill did not expressly declare that they bound the states. Nor could Congress enforce the Bill of Rights since, according to the basic principles of constitutional federalism, Congress lacked any enumerated power to enforce the Bill of Rights. The result was a Constitution that Reconstruction Republicans believed declared the rights of national citizenship, but which failed to give the branches of the national government power to enforce these rights against state abridgment. And it was this omission that Ohio Representative Bingham wanted to remedy. On February 28, 1866, when Bingham submitted his first draft of the Privileges or Immunities Clause to the House, he declared, quote, "The proposition pending before the House is simply a proposition to arm the Congress of the United States, by the consent of the people of the United States, with the power to enforce the Bill of Rights as it stands in the Constitution today. It hath that extent, no more." On March 9th, Bingham again declared that the enforcement of the Bill of Rights against the states is the want of the Republic. Therefore, Bingham said, "I have advocated here an amendment which would arm Congress with the power to compel obedience to the oath and punish all violations by state officers of the Bill of Rights," end quote. Then on May 10th, following the submission of Bingham's final draft to the House, once again Bingham declared, "There remains a want in the Constitution of our country which the proposed amendment will supply." Bingham's proposed Privileges or Immunities Clause would prohibit states from passing unconstitutional laws, laws that violated the enumerated Eighth Amendment's protection against cruel and unusual punishments. And again Bingham declared, "That is the extent it hath, no more." Finally, in 1871, a few years after the ratification of the 14th Amendment, Bingham explained what led him to draft the final version of the Privileges or Immunities Clause. Quote, "Jefferson well said of the first 8 articles of amendment to the Constitution of the United States that they constitute the American Bill of Rights. They secured all the rights dear to the American citizen, and yet it was decided, and rightfully, in Barron v. Baltimore, that these amendments, defining and protecting the rights of men and citizens, were only limitations on the power of Congress and not on the power of the states." Bingham had therefore drafted a clause that would allow Congress to, quote, "safely follow the example of the makers of the Constitution and the builders of the Republic by passing laws for enforcing all the privileges and immunities of citizens of the United States as guaranteed by the amended Constitution and expressly enumerated in the Constitution." This was Bingham's vision, a vision embodied in the text he drafted and presented to Congress and to the public. The rights of American citizenship, the privileges or immunities of citizens of the United States, were those rights, quote, "expressly enumerated in the Constitution, which prior to the adoption of the 14th Amendment were only limitations on the powers of Congress and not on the powers of the states. These enumerated rights included the equal rights covered by Article 4 and discussed in Corfield against Coryell, and also those listed in the 1791 amendments. The Supreme Court betrayed this vision of the Privileges or Immunities Clause, but not in Slaughterhouse. It was in United States against Cruikshank, a decision in which the court refused to treat constitutionally enumerated rights as the privileges or immunities of citizens of the United States. This is the decision, and this is the reasoning that the current court should reverse. By adopting the enumerated rights reading of the Privileges or Immunities Clause, the court would finally justify the incorporation of the Bill of Rights, while at the same time preserving constitutional federalism and the people's retained rights of local self-government. Self-government in all matters not expressly given into the hands of the federal government, including the federal courts. The privileges or immunities of citizens of the United States are those rights which the people themselves have declared to be the fundamental rights of national citizenship. This, too, is a right of the people. The right to decide for themselves what matters ought and ought not remain the subject of local democratic debate. All of these rights are preserved and maintained by the enumerated rights reading of the Privileges or Immunities Clause. Two final brief thoughts. Randy has recently authored a lengthy article titled "Why Kurt Lash is Completely Wrong." It's available on SSRN. I have written an even longer response titled, "Give it a rest, Randy, you know that I'm absolutely right." I have also posted my article on SSRN, and it is available for downloading and study. But regardless of the debate between Randy and myself and my fellow panelists, I'm happy to say that all of us will soon have in our hands a collection of historical documents that will allow all of us to reach our own conclusions regarding the historical record. As Judge Thapar mentioned, I'm under contract with the University of Chicago Press to publish 2 volumes of materials relating to the framing and adoption of the 13th, 14th, and 15th Amendments. This will include the major debates, both inside and outside of Congress, essays written by women's rights groups, freedmen associations, conservative Democrats, and radical Republicans. Everything's going to be in there, and amazingly, no such collection currently exists. So by next year, we can continue this debate with an even deeper understanding of the historical record, and I look forward to doing so. Thank you.
Thank you so much for having me. I highly encourage you all to download those Notre Dame articles, but they're both wrong, for the record. So I have the unique advantage of not having actually made my views of the Privileges or Immunities Clause publicly known, except on Twitter. And I went back and deleted all those tweets before this panel. So I have the edge here by being the only person who's read what I have written on the Privileges or Immunities Clause. So, but joking aside, it is a real honor for me to be here on this panel with 3 giants in the field. But it is also something of a terror. This is all the more so because I'm about to suggest that although they're right about most things, they're probably all wrong about the original meaning of the Privileges or Immunities Clause. I say this, of course, with utmost respect and, as I said, terror. But the debate thus far has been between 2 positions. Does the Privileges or Immunities Clause only incorporate the Bill of Rights, or does it also protect other unwritten fundamental rights against state action? I am here to suggest that according to the best reading of the Privileges or Immunities Clause, it probably does neither. The Privileges or Immunities Clause says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. I want to suggest that the clause does not guarantee any fundamental rights against state action. Rather, the clause is an equality provision with respect to state-created or state-protected civil rights. This means that a state could, for instance, cabin the right to contract as much as it wants. And it could, I suppose, prohibit handguns. But what a state can't do is prohibit only blacks from owning guns or only Asians from entering into certain kinds of contracts. The evidence I want to lay out goes as follows. First, the Privileges or Immunities Clause was intended to constitutionalize the Civil Rights Act of 1866. We've heard a bit about this. And only the anti-discrimination reading succeeds in that task. The Equal Protection Clause doesn't do the job. Second, the very historical problems that Professor Zitlow and others like Michael Kent Curtis and Akhil Amar have written about, the general abridgment of civil liberties, and particularly free speech and press rights in the antebellum and postbellum periods, would actually be solved by the anti-discrimination reading of the clause. First, let's start with the Civil Rights Act of 1866. At least 18 members of the 39th Congress explicitly connected the 14th Amendment with the purpose of constitutionalizing this act. Compare that to only 2 who said anything about what today would be understood as incorporation. And even these statements are hardly good evidence. I'll actually eat into my response time by just pointing out that the two statements we've heard about incorporation are Professor Lash mentioned John Bingham, and Professor Barnett mentioned Jacob Howard. When John Bingham said he wants to enforce the Bill of Rights as it stands, there is strong evidence to suggest that he did not mean the Bill of Rights as we know it today. The Bill of Rights did not become a term of art, referencing the first 8 amendments to the Constitution until well after the 1890s. Recent historical scholarship has demonstrated this. But more than that, Jacob Bingham himself defined the Bill of Rights, his Bill of Rights, in numerous speeches in Congress as the Due Process Clause and the Comity Clause, both of which, the Privileges and Immunities Clause, both of which are independently written into the 14th Amendment, outside of the Privileges or Immunities Clause. As for Jacob Howard, he did. He is the only person who said anything about the first 8 amendments and applying them against the state. Why was Jacob Howard, the radical senator, introducing this to the Senate? Because the chair of the Reconstruction Committee, William Pitt Fessenden, who didn't agree with Jacob Howard about this, was sick that day. No one else mentioned the 8 amendments or incorporating them, either in the debates in Congress or in the ratification debates. John Bingham later mentioned them in 1871, 5 years after the fact, and here he mentioned the first 8 amendments, not the Bill of Rights. Okay, that was a tangent. I ate into my response time. Back to the point, 18 members, in contrast to these two who said anything about what might be interpreted as the Bill of Rights, 18 members wanted to constitutionalize the Civil Rights Act. Why does this matter? What was the aim of the Civil Rights Act? It was to nullify and neuter the various black codes that had arisen in the South after abolition. In these black codes, these southern state governments systematically denied blacks the same rights that were enjoyed by white citizens. Blacks could not own real property. They could not even rent in some states except under the supervision of town authorities. Blacks were required to enter into contracts, often agricultural contracts, by a certain day in January each year, lest they be deemed vagrants under the law, subject to punishment, imprisonment, and being forced into employment. Blacks could not testify in courts to the same extent whites could, and blacks, not whites, only blacks, were prohibited in several of the states from assembling and from owning daggers, swords, and firearms of any kind. Hence, the Civil Rights Act of 1866 declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. And such citizens, again, what citizens? Citizens of the United States. Such citizens of the United States, of every race and color, shall have the same right in every state to make and enforce contracts, to sue, be parties, give evidence, inherit, purchase, lease, sell, hold, and convey real and personal property, as is enjoyed by white citizens. Note what the Civil Rights Act does and doesn't do. It does not guarantee any rights. It does not define any of the rights it lists. It instead guarantees only that whatever civil right a state happens to give its white citizens, it must also give its black and other citizens. Note also the terminology. Professor Lash says that the privileges or immunities of, quote, citizens of the United States was a term of art referencing the Bill of Rights and other enumerated federal constitutional rights. But note how it is used in the Civil Rights Act. The act declares anyone born in the United States to be a citizen of the United States, and then says such citizens, again, such citizens of the United States, are entitled to equality with respect to provisions of state-created or state-protected privileges and immunities. Consider also Andrew Johnson's veto message. The bill, he said, quote, contains an enumeration of the rights to be enjoyed by those classes so made citizens, again, citizens of the United States. These were a host of state-created privileges and immunities. Now, Johnson vetoed the bill for this reason. He believed there was no federal power over these state-protected privileges. But that's exactly why we needed the 14th Amendment, and particularly the Privileges or Immunities Clause. Well, doesn't the Equal Protection Clause constitutionalize the Civil Rights Act? And if so, doesn't that make the Privileges or Immunities Clause superfluous under my reading? Well, the Equal Protection Clause does not mean what we have all been led to believe. We've all been led to believe that equal protection of law means equality generally, and then we get the Civil Rights Act equality reading, no problem. But in fact, It means something much more specific: equality with respect to the protection of the laws. What was the protection of law? In short, the protection of law was the flip side of due process of law. Due process of law provides the mechanism by which someone may be deprived of life, liberty, or property, only by the government and only according to established law and known procedures. The protection of law is the flip side. It is the protection the law must afford to you, to your enjoyment and exercise of those life, liberty, and property rights against private interference. This means the government must actually protect you, for example, by providing police services or intervening against mobs. And it means the government must give you redress in courts so you can sue for trespass, battery, or what have you. I shall rest this case on two authorities, Blackstone and John Marshall. When discussing the remedial part of the law, Blackstone wrote that the method of recovering and asserting rights when wrongfully withheld or invaded is what we mean properly when we speak of the protection of the law. And in Marbury v. Madison, Marshall wrote, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. The Equal Protection of the Laws Clause does not constitutionalize the Civil Rights Act of 1866 because the protection of law says nothing at all about the content of liberty or property rights. It merely means that whatever liberty and property rights a state happens to give a subject according to its laws, the state must also give that subject the protection of law so that she may enjoy and exercise those liberty and property rights. Well, this takes me to my second, shorter point, responding to the historical analysis of several scholars like Professor Zitlow, Akil Amar, and Michael Kent Curtis in the modern literature. Yes, it is true. There was a tremendous problem with the abridgment of civil liberties in the antebellum and also postbellum period. The South repeatedly denied First Amendment rights to abolitionists, and this greatly concerned the Republican Party. And of course, the South repeatedly denied Second Amendment rights to the newly freed men in the Black Codes. But the anti-discrimination reading of the Privileges or Immunities Clause solves these very historical problems that supposedly point to incorporation. After all, the problem wasn't that the Southern governments didn't have any First Amendment protections. They all did. Each and every Southern state constitution had a First Amendment equivalent. The problem, rather, was that the states were selectively denying this right to specific populations, to blacks and to abolitionists. The same goes for the Second Amendment. Again, the problem wasn't that Southern governments were denying this right writ large, but rather they were denying them to blacks only. An anti-discrimination reading of the Privileges or Immunities Clause would solve these problems because state constitutional rights are privileges and immunities of state citizenship. And so the South must now provide those privileges and immunities equally and not selectively. In conclusion, it seems to me that the best reading of the Privileges or Immunities Clause is that it neither incorporates the Bill of Rights nor gets us to unenumerated rights as in Lochner. Instead, it requires only that whatever privileges and immunities a state affords some of its citizens, it must afford all of its similarly situated citizens, free of arbitrary discrimination. So we may not get Lochner, but that doesn't mean Slaughterhouse was right. There, it seems to me, there may in fact have been arbitrary discrimination in the provision of a state-created privilege and immunity. Now let me add the following. All I am saying, lest I get in trouble, all I am saying is that the best original meaning of the Privileges or Immunities Clause is the anti-discrimination reading. That does not mean it's the only possible reading. Perhaps one of the fundamental rights approaches advocated by my co-panelists is a plausible reading, sufficiently plausible that maybe it's become the liquidated, fixed, and settled meaning of the provision. This would be consistent with some originalist methodologies. I've also said nothing about the Due Process Clause, which may incorporate the Fifth, Sixth, and Seventh Amendments, even under the correct historical understanding of due process of law. And finally, I've said nothing about whether we should even care about the original meaning of the Privileges or Immunities Clause if that meaning doesn't get us incorporation. My remarks don't bear on any of those possibilities, which we must leave for another day. Thank you.
Before we move to questions, I'd like to ask the panelists if you have any brief rebuttal. Brief. Go ahead. Can we turn that? Push the button.
One of the points that I wanted to make about Kurt's talk, Ilan has already made, and that is that most of the quotes that you heard from Kurt that use the phrase Bill of Rights are using a phrase that did not have a standardized meaning until the 20th century. I highly recommend the book by Gerard Maglioccia. It's called The Heart of the Constitution, How the Bill of Rights Became the Bill of Rights. He discusses the fact that there was no standardized meaning. The term actually first starts getting used around the time of the Civil War, but it didn't get associated with the first 8 amendments and only the first 8 amendments until into the 1930s and 40s, and it was actually something that was stressed by the Roosevelt administration as a way of justifying their expansive use of governmental power by saying, hey, look, what we're doing is okay because we're not violating the Bill of Rights, which means just those 10 amendments. And since we haven't violated those 10 amendments, everything else that we're doing is okay. And that's when the Bill of Rights became a salient matter. Ilan also correctly points out that when Bingham used the Bill of Rights, and Kurt knows this, he just didn't have time to tell you this, he referred both to amendments, like the Fifth Amendment, and he referred to Article 4, the Privilege and Immunities Clause, as part of Bingham's Bill. That was part of Bingham's Bill of Rights. So again, later scholars have criticized Bingham for being, erratic and not understanding what he's talking about with respect to the Bill of Rights. But it's the later scholars that are the problem because Bingham was using a word that didn't have a standardized usage, and he defined what he meant by it. More? Well, just for Ilan. Just not for you. So Ilan puts forward the proposition, I was trying to follow it, that the privileges or immunities of citizens of the United States are the privileges or immunities of the states. This is not an obvious reading of the clause. I'll just point that out. It sounds like it's the privileges or immunities of citizens of the United States. That's what it sounds like. That's what the clause says. The only other point I would make is he wants to disparage Jacob Howard's speech because he says Jacob Howard was filling in for the lead sponsor who was ill that day. Jacob Howard's speech was, and his definition of privileges or immunities was not contradicted by any other member of the Senate after he gave it. It was widely reported in the press. It was so widely reported in the press that the 14th Amendment became nicknamed as, I say Howard, did I say Bingham by mistake? But, okay, so it became nicknamed the Howard Amendment. That's how widely reported his speech was. So I don't think that Ilan can dismiss Howard's description of the privilege immunities quite so easily as he just did orally, but I await seeing his written paper so we'll know exactly what he says.
Send it to you later.
Just a brief remark, because both Randy and Ilan talked about the non-standardized understanding of the Bill of Rights. There's no reason for the audience to panic. If you're hearing for the first time, oh my gosh, the term Bill of Rights doesn't mean what we thought the term Bill of Rights meant. There go all of the papers that we've written, over the past 10 years. It's not true. Gerard Magliocca has shown that by the time of 1860, the Bill of Rights was commonly understood as a reference to the enumerated rights of the 1791 amendments. It was throughout the Reconstruction Congress, references to the Federal Bill of Rights was understood as a reference to those amendments. And for a complete investigation and just a mountain of evidence that, don't worry, the Bill of Rights means exactly what you thought it meant, go ahead and take a look at the paper that I've just posted on SSRN. But I want to say one last thing about John Bingham. It is true, at one point, it was just in February, he never did it again. In February, Bingham described the Bill of Rights as including Article 4, the Comedy Clause of Article 4. Bingham, at this point, had declared that his efforts were guided towards enforcing the Bill of Rights against the states, and he was trying to find some type of textual mechanism for doing that. And he had long argued, this goes all the way back to 1859 in his Oregon speech, which Rebecca referenced, I think, in your talk. He argued that a correct understanding of the privileges and immunities of citizens in the several states, that was the text of Article 4, if you read it correctly, you would read it as including an unstated ellipsis referencing the citizens of the United States who were citizens in the several states. It was kind of a complicated argument. But basically what he was arguing is that Article 4 should be understood as the vehicle for obligating the states to enforce the Bill of Rights. And so in his February speech of 1866, he bundles them all together at that point, arguing that Article 4 and the Bill of Rights all together should be understood as binding the states. And it's something that we should pursue in binding the states to enforce the Bill of Rights. It didn't work as a complicated argument. You probably haven't followed it right now. Neither could his fellows in Congress, and so he abandoned it. And he changed the language to expressly calling for protection of the privileges and immunities of citizens in the United States. So it was a brief flurry where he included Article 4 to try and use it as a vehicle to enforce the Bill of Rights against the states, which was his never-ending desire. And when he said Bill of Rights, everyone knew what he meant, and Gerard Maglioka agrees with that point. Everyone knew what he meant.
Well, I'll just say two brief things. The fact that no one contradicted Senator Jacob Howard maybe isn't surprising. The 14th Amendment was a long speech, has 5 sections, the second section of which, about representation in the South in Congress, actually took up most of the debate. I mean, this puts a lot of weight on a single statement made by a single senator that no one commented on or contradicted. I mean, compare that to dozens and dozens and dozens of statements in Congress, on the campaign trail, in public, that said, what are the Speaker of the House, Colfax, on the campaign trail for ratification, said, what are the privileges or immunities of citizens of the United States? We defined them in the Civil Rights Bill of 1866, said this in public. Dozens of speakers from Congress made sort of the same point. As for the textual point, I agree it's not an obvious or natural reading. But let me read to you the first 2 clauses together of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The 14th Amendment declares that there's this category of persons that are citizens of the United States who have rights, privileges, and immunities under both federal law and state law. So I agree, the Bill of Rights and all the privileges and immunities conferred by federal statutes are privileges and immunities of United States citizens. They all are. They are privileges and immunities of citizens of the United States. They're just privileges and immunities that we have as against the federal government. The states have no power to abridge those at all, because those are rights that we get from federal law that the federal government can abridge. There's a whole set of other state privileges and immunities that the states can abridge. And the 14th Amendment says it is now a privilege of United States citizenship that whatever states give you as your privileges and immunities, it must do so equally. That is now a privilege of United States citizenship. QED.
All right, so this is the Student Symposium, so I can ask questions, but I want to give you all the first shot while you have time. And please, the one thing I ask is you actually end with a question mark and ask a question. All right. Yes, right here. Yeah. Yeah. So you can, are mics on both sides? Yes, so you can just come down and then I'll know.
Don't be shy.
And I'm going to alternate sides.
Thank you, Judge Thapar, and thank you to the panelists. I know it's a long time ago, it seems, but on the terms of the talk, but pardon me, Professor Barnett, for using Professor Lash's terminology, but if you're going to propose a unenumerated rights interpretation of the Privileges and Immunities Clause, I believe that you brought up something about to favor measures that the states are competent to address. In terms of that, and that came up in the Virginia plan at the original Constitutional Convention, et cetera, what what meaning do you supply to the matters that the states are competent to address?
Oh, great. That was from 1868 and afterwards supplied by what's called the police power doctrine. And because only with the passage of the 14th Amendment did it become necessary for there to be a police power doctrine that would say what the proper competence of state legislatures were, so that the Privilege and Immunities Clause, or the 14th Amendment, would then hold them in check, hold them to those powers. And so once it became necessary to have such a theory was developed. It was police powers doctrine. It borrowed on earlier state police powers cases as well, but then it refined them. So the general rubric that we use is health, safety, the public morals, or health, safety, morals, and general welfare. But health and safety and the public morals was the most frequent way of putting these police power. And so that is the ends to which state legislative powers are competent. What they're not competent to do is, for example, to take from A to give to B, just because in the legislature's wisdom, they would like this person to have property that that person previously has. That's not something that legislatures are competent to do. And there's other things that they're not competent to do. So once you identify what the proper ends of government are, then you can ask whether a particular law is actually rationally related, reasonably related to that proper end or not. And actually, the standard that I favor is what you all know to be the rational basis test. That is, a law must be rationally related to the means adopted must be rationally related to an end to which the state is competent. Except that it is a real rationality test, not the hypothetical or conceivable basis rationality test that the Supreme Court adopted, that the Warren Court adopted in the 1955 case of Williamson v. Lee Optical.
Thank you. My question is, each of you presented a common understanding of these rights, and I believe Professor Zitlow talked about the abolitionist constitutional advocates, and yet I had a difficult time wrapping my mind around their influence on the process because of the equal or additional influence of such advocates as the American Colonization Society, if we're thinking about it in historical terms, and other abolitionist advocates such as Judge and Professor St. George Tucker, who advocated that the freed slaves should be sent to be incorporated in towns somewhere on the western frontier. And one of Professor Tucker's students actually attempted to realize that plan at one point. So how would you defend your understanding of the purpose from a historical perspective with these Republican abolitionist constitutional advocates against other constitutional advocates of that era?
Well, certainly there was the pro-colonization movement going on at the time, but the anti-slavery constitutionalists were not advocating for colonization. And by the way, they were advocating a very broad reading of citizenship rights that Randy's been talking about, Jacob Howard. They were active in the Republican Party. They were active in the Liberty Party. I mean, they were actually engaged in the formation of the ideology of the party and the folks that were then elected to Congress and became leaders in the Reconstruction Congress. So that's the reason why I think it's quite clear that their ideologies had an impact. And you can hear, for example, James Ashley, the person that I wrote the book about, invoking much of the anti-slavery constitutionalism in his speeches before Congress. John Bingham, also Jacob Howard as well. And so they were the ones that were the leaders in the Reconstruction Congress, which enacted the 14th Amendment, not the folks who supported colonization.
Thank you all very much. So this term, the case Timbs against Indiana explained that the excessive fines clause was incorporated against states. I was wondering, there were two different justices that signed on to a privileges or immunities sort of understanding of why that was the case. If you were to give advice to maybe more Supreme Court justices that were not yet persuaded that that is the right way to go, where do you think the focus should be on persuading more justices to adopt that viewpoint?
That's a good question. I don't know.
Well, if you think that viewpoint is wrong, then actually, you know, the whole premise of the question is sort of taken from under it.
Yeah, I think it's for this side of the
yeah.
Well, you think the excessive fines clause is part of the privileges and immunities of citizens. You think the excessive fines clause is part of the privileges and immunities of the United States as well, right? It's an enumerated. Yeah.
Oh, absolutely.
So I thought the question is for. Oh, you're including.
Well, I was including
myself. Okay,
myself.
yeah, it's the 3 against 1. That's good. I like that. Well, look, I think one of the things that I would say to them is, what are you afraid of? What are you so afraid of? I know what they think they're afraid of. They think they're afraid of an open-ended Pandora's box in which once you allow the protection of what's called unenumerated rights, then anything goes. But that's no more true of the textually appropriate place to find rights than it is of the Due Process Clause, which is what the court currently has. All the justices now, I mean, the majority in the case was a substantive due process rationale. So any problems you might have with an open-ended reading of unenumerated rights, you're going to have with substantive due process. The reason why they think they don't is because they think they have a doctrine associated with Glucksberg, which basically says that, you know, the rights have to be defined at the most specific level and then deeply rooted in the nation's tradition and history. They think they've got the substantive due process right in a box, but they don't. That Glucksberg gets ignored whenever the votes are there to ignore it. So they just ought to do what Justice Thomas has been urging them to do for a long time, and then focus on the right provisions and deal with the history that you find, and then make up your mind about that. And I think the history is more than ample to provide constraints on what these rights are, that the open-ended modern substantive due process doctrine does not provide.
And I agree that the court should not resist revisiting the Privileges or Immunities Clause simply due to fears about uncabined doctrinal development or something along those lines. I don't share Randy's view. I do think that his particular view would undermine a very important separation of powers principle. I don't think that his particular view would lead to human flourishing, but I have a particular theory of human flourishing that's different from Randy's. Randy may have the correct view, and if it is the correct original understanding of the Privileges or Immunities Clause, the court should simply do what is right. If that is what the people have adopted, if the understanding of the people at the time of the 14th Amendment embraced this conception of liberty and embraced this conception of federalism, then the court is obligated to enforce what the will of the people was in 1868. Now again, I have a different approach. I don't think so. I think that federalism is preserved. I think that the historical evidence strongly suggests that the court could embrace the Privileges or Immunities Clause without eradicating constitutional federalism or opening the door to the extent that Randy would go. But I really think that it's a poor excuse for a court to continue on a judicial construction which has nothing to do with what the people actually wanted. And they should simply acknowledge the fact that scholarship has moved to the point where they must address new understandings of the Privileges or Immunities Clause. Elon could be right. Elon could be right, and in which case they have an obligation to explain that to the people. Simply ignoring the clause just doesn't seem to me to be ethically responsible.
If I could just ask you a question, Kurt, and the people out here don't really realize that we actually are good friends. They think they think we're just saying that for purposes of the panel, but we actually are friends. But I've never heard you opine on human flourishing before. So I don't know that we really disagree about human flourishing. Have you written about this somewhere? So I would know whether we actually disagree about this or not?
Check Twitter.
Well, it'll be posted by the time we're done with this particular.
That's the problem with dealing with Kurt. It's going to be. How many pages will it be?
So I'll jump in here just real quick and say that I think the justices should not be afraid of delving into the original meaning of the Privileges or Immunities Clause. I would just encourage them to wait a year or two until my next book comes out on this. My editor at Cambridge told me to pump the brakes a little bit, but I think I'm going to come back to him with this argument. However, until then, just so you know, there are at least 2 living scholars still alive today who agree with me, mostly. Chris Green at the University of Mississippi, who has a short book at Rutledge University Press on the Privileges or Immunities Clause, and John Harrison. So if you want to read at University of Virginia, so if you want to read something about this, read John Harrison's 1992 Yale Law Journal article, Reconstructing the Privileges or Immunities Clause, which I think is mostly right. And more important than any of that, this was David Curry's view. And I don't think David Curry was wrong about anything ever. And so I'll rest with that.
Again, thank you so much for coming. This is my question. Do you believe that there's a proliferation of rights, or at least a proliferation of emanations or penumbras of rights? If so, do you believe that this subverts the meaning of the Immunities and Privileges Clause?
The emanations formed by penumbras, which is in Griswold versus Connecticut, was Justice Douglas's effort to get around footnote 4 of U.S. v. Caroline Products, which limited heightened scrutiny to the specific prohibitions, such as those in the first 10 amendments, which is what footnote 4 talks about. And so because he was committed to that, but he wanted to protect the right to use contraceptives, for married couples to use contraceptives, which is obviously not in the first 10 amendments, he came up with this emanations formed by the penumbras of the specific prohibitions in order to bring that unenumerated right in. So that whole way of looking at things, that modern substantive due process way of looking at things, is a result of limiting the scope of constitutional protection simply to the enumerated rights without taking into account, for example, either the Privilege or Immunities Clause or the Ninth Amendment, something else that Kurt and I don't agree about.
Thank you all for a great panel. My question is just, if the Bill of Rights is enforced against the states through the Privileges and Immunities Clause, is it the understanding of the Bill of Rights in 1791, or is it the way the framers in 1868 understood the Bill of Rights?
I'm happy to take that one. I just don't want to. I don't want to monopolize. Do you want to address that? No. Okay. It's an enormously difficult problem that scholars have struggled with. If you accept, and not everyone does, but if you accept the idea that the Bill of Rights were applied against the states by way of the 14th Amendment, was the understanding of First Amendment freedom of speech that is to be applied against the states the original understanding of freedom of speech, which perhaps was far more narrow and more common law bound than that which developed at the time of 1868? Or do we adopt the broader view of freedom of speech and have one vision, one broad vision of freedom of speech that we apply against the states with a very narrow vision of freedom of speech that we apply against the federal government? My solution to this problem is to understand the 14th Amendment as a re-articulation, a re-speaking of the rights of the people. When the 14th Amendment said, no state shall make or enforce any law abridging the privileges or immunities of citizens of the United States, they were re-speaking what counts as the privileges or immunities of citizens of the United States. And if in their mind that included a freedom of speech clause, and that their vision of freedom of speech that they believe bound the federal government should also bind the states, at the same time then, they re-invoked freedom of speech, and we now have a unitary, broad, I would say, freedom of expression. But it takes a lot of theoretical work to arrive at that point, and this is yet another thing that I guess I'll have to post on at around 2 a.m. tonight, something along those lines.
Very, go ahead.
Okay, I think that raises a more essential question, and that is, what did the Reconstruction Amendments do to the Constitution? Did they just change it at the edges, or did they fundamentally transform it? And I think the Reconstruction amendments did fundamentally transform the Constitution, the entire Constitution, and that the Reconstruction era really is properly understood as the second founding. And so it doesn't exactly answer your question, but I do think that you can't, I guess it does. You can't go back to 1791. I mean, you've got to at least start with 1868.
The only thing I would add is this is another really hairy constitutional and historical problem that we wouldn't need to solve under the correct reading of the Privileges or Immunities Clause.
Look, just say it's an ink blot and be done with it.
Oh, it's not an ink blot. It's very clear. It requires
if you say
equality in the provision of state.
But if you say it's an ink blot, then look how easy everything gets. You don't have to worry about it at all.
It's not an ink blot, but it is narrower than some.
I think this was a good opportunity to say that I think modern incorporation doctrine is not the proper way of thinking about how the rights get protected by the 14th Amendment. Justice Harlan, when he first recognized that it violated fundamental rights for a state to take private property without just compensation, did not mention the Fifth Amendment takings clause when he did that. The proper way of thinking about this is what rights were thought to be fundamental rights of American citizens when the 14th Amendment was enacted. Not the First Amendment, Second Amendment, Third Amendment per se, but what rights were fundamental at that time. And that's what the quotes that I read are talking about. They're trying to identify what rights were thought to be fundamental.
Hi. I wanted to tie back to economic liberty and ask each of the panelists whether you think the 14th Amendment protects economic liberty, like the rights involved in Lochner, and in what clause? If not the Privileges or Immunities Clause, then where?
It's not just the 14th Amendment, it's also the 13th Amendment. I mean, the 13th Amendment is the one that's really about economic rights, the abolition of slavery and involuntary servitude. So I guess I don't see the need as much to look into the 14th Amendment for that reason.
And Dana, my answer to your question is yes, the Privileges or Immunities Clause absolutely protects economic liberty. It protects contract right, property rights, and all the same. How does it protect it? It says whatever contract rights, whatever property rights that exist under state law must be afforded equally to all citizens of any skin color, national origin, religion, what have you. That means a state, if it wants, I suppose, could prohibit contracts for labor over 10 hours a day. What it can't do is say Asians can't labor more than 10 hours a day. Or what it can't do is say you can't run laundromats in wood buildings when it turns out 90% of the laundromats in wood buildings are run by Asians in San Francisco, right? That it can't do. But if it applied it equally, I think, it is up to we the people exercising our capacity for self-government to ensure that the role of law and the role of government stays in its proper place in the economic sphere.
Just briefly, one of the things that is interesting that I noticed in the collection of documents that I'm putting together are the arguments over the 13th Amendment that happened during the framing of the 14th Amendment. And equally interesting are the discussions of the 14th Amendment that happened during the debates over the 15th Amendment. There's a lot of wonderful, wonderful stuff in there. And there was a lot of dispute. I think Rebecca would agree. There was a great deal of dispute in the 39th Congress as to whether or not the 13th Amendment and Section 2 of the 13th Amendment gave Congress sufficient power to protect economic rights. Some radical Republicans believe that it should be read that broadly, but not everyone did. And John Bingham, for example, was one who didn't believe that it did. And all I would say is this point, again, it's a very complicated, very important question. I tend to always start with John Bingham, the framer of the 14th Amendment, at least in beginning my investigations. And Bingham believed that the economic rights that they were trying to protect and give equal protection to in the Civil Rights Act of 1866 should not be understood as an enforcement of Section 2 of the 13th Amendment. He believed what they were trying to do was to secure the equal rights of life, liberty, and property, including the development of property, as declared by the Fifth Amendment's Due Process Clause. And what I have argued in writing is that we should look to the Due Process Clause, and perhaps the combination of the Equal Protection and Due Process Clause, as protecting the economic rights that you find in the Civil Rights Act of 1866.
Can I jump in there, Judge Lamar? I'm not sure that that argument entirely works. I know Professor Lash just published an excellent article about this in Georgetown, right, a year ago, which you should all read. But the important point to understand is that all three provisions, equal protection of law, due process of law, and the Privileges or Immunities Clause, protects your fundamental rights to life, liberty, and property. The fact that it references life, liberty, and property does not mean it's about due process. Each three provisions protects your fundamental rights to life, liberty, and property in different ways. The Privileges or Immunities Clause, it's a nice little trinity. The Privileges or Immunities Clause says, whatever positive law exists for the protection of natural rights to life, liberty, and property, this is what they understood civil rights to be, a state must afford all citizens equally, free of arbitrary discrimination. The Equal Protection Clause says, and you must give them protection of law so they may enjoy and exercise those rights to life, liberty, or property, free from private interference, free from mob action and mob rule. It must give you access to courts to vindicate those rights. And the Due Process Clause says, and if the government wants to come take away those rights, it must do it under these conditions, following due process of law. Established law, pre-existing law, according to known procedures. So they all relate to life, liberty, and property, just in different ways.
Dana, my answer is, I gave it in the course of my talk. I think that the 14th Amendment includes the protection by the government, the enjoyment of life and liberty with the right to acquire and possess property of every kind. That was Corfield quoting essentially from George Mason. And the Civil Rights Act protects the right to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property. These are expressed expressions of the economic rights that were protected by the Privileges or Immunities Clause, in my view. As for the Due Process Clause, this is not a panel on the due process of law, but I just want to note that Evan Bernick and I have an article forthcoming in the William and Mary Law Review on the original meaning of the due process of law called No Arbitrary Law, and you can download that also. It's currently available on SSRN if you want to see our view of the original meaning of the due process of law.
Hello, thank you for being here. My name is Ryan from Georgetown, and my question is primarily for Professor Werman. You were the one that brought up the fact that the Bill of Rights may not have been, as a term of art, understood as late as 1860. And then Professor Lash and Professor Barnett had an exchange where they gave us two very different readings of Gerard Magliocca's scholarship. And I was wondering what scholarship he was referring to. If not Magliocca, is there more? And then if you could tell us a little bit about your reading of it that makes you conclude that it was not understood as a term of art by 1868.
We should have another panel on the original understanding of Gerard's work because I have a very, he has an article in 2016, also in Notre Dame Law Review, right? Where I think it's called the Bill of Rights as a Term of Art. And, I haven't read everything that he's written on this. I've read that, and I think that supports the point I made. But don't forget that Bingham himself said by the Bill of Rights, he meant the Fifth Amendment, and particularly the Due Process Clause, and the Privileges and Immunities Clause of the original Constitution, both of which are independently constitutionalized as against the states in the 14th Amendment outside of the Privileges or Immunities Clause. The first sentence, right, declaring citizens, anyone born in the United States to be a citizen of the United States, incorporates Article 4. As Professor Zitlow said, the whole question of Comedy Clause rights was if free blacks aren't citizens of the United States, then they aren't entitled to these comedy rights. Well, first sentence of the 14th Amendment says they are citizens. Automatically, they're entitled to those privileges or immunities. And then, of course, there's the privileges and immunities, the comedy rights. And, of course, we have the Due Process Clause. And maybe the proof is in the pudding here. In 1871, when Bingham said, oh, yeah, 5 years ago, this is what I intended to happen, he didn't say Bill of Rights. He said the first 8 amendments. That's what he kept saying. And I think it was future President James Garfield who said, I was there, buddy, and I don't remember you saying that. Like, you can say it, but that doesn't make it so. And so, I've not read everything Gerard's written or everything Bingham has ever said, but that's the argument.
I would also add the late historian Pauline Meyer has also written a piece. It's published in the Georgetown Journal of Law and Public Policy that laid out the initial thesis. It was her judgment that that was true, and Gerard's project picks up where her research leaves off. So she's the one that actually kicked off that idea, and that's the person from whom I first heard the idea that the Bill of Rights. And I heard about it when she contacted me, and she said, hey, look, you've been doing all this research on anti-slavery constitutionalism before the 14th Amendment. Did you come across any time in which they referred to the first 10 amendments as the Bill of Rights? And I hadn't thought about it, because I was like everybody else. I assumed the Bill of Rights just meant the first 10 amendments. And so I did a digital search of all the records that I had come across, and I couldn't find a single example of any anti-slavery lawyer who said, who invoked the amendments, and they did invoke the amendments, but I didn't find a single example of them referring to the amendments as being a part of the Bill of Rights. Not one.
Thank you all for being here. I'm Bryce from the University of Pennsylvania. My question was for Professor Werman. I'm curious as to what flavor of, oh, don't get so sad. My question was, what flavor of anti-discrimination are you reading into the Privileges or Immunities Clause? So what I'm thinking is, are you thinking the protection against the states is on facially neutral policies, or would you read a disparate impact theory into the Constitution?
I don't know exactly what I think about that, about disparate impact. I certainly think facially neutral laws, however, can be invalidated if you have proof of discriminatory intent, and maybe proof of discriminatory intent comes from disparate impact. But this is a very, very good question. I actually think I agree with Professor Barnett a lot more than I've let on in terms of the role of the police powers, because what a state would do, right, if someone like the butchers in Louisiana said, my privileges and immunities are being abridged through a discriminatory provision, the state could come back and defend its laws on the ground that it legitimately exercised the police powers. So that's how the analysis would go. But critically, this analysis wouldn't be triggered unless the legislation was discriminatory, right? In other words, if it says we prohibit all people from entering into labor contracts more than 10 hours a day, that may not be a legitimate exercise of the police power, but it wouldn't violate the Privileges or Immunities Clause because it's not discriminatory. So the police powers does work in the analysis, but discrimination has to be present to trigger the work of the police powers. And this is a paper that should be coming online in a few weeks.
Professor, you get to finish.
Oh, thank you. Several of the panelists mentioned that one of the privileges or immunities of citizenship is the protection of the government, and implying an entitlement to federal action. And so I'm wondering if anyone would like to elaborate on that and its implications, say, for the DeShaney decision, which seems to have rejected that opinion, or perhaps the current litigation in Juliana versus United States, the so-called kids' climate case, which is based in part on a theory that the federal government has a constitutional obligation that is judicially enforceable to restrict greenhouse gases in order to protect future generations from harms caused by private economic activity.
Yes, there's a lot of evidence that they, the framers of the 14th Amendment thought that people were entitled to the protection of the government against private violations of rights. They often talked about the protection of the government. They knew that, after all, if you consider the fact that slavery was, in fact, the private ownership of people, right? It was sanctioned by law in the slavery states, but still was the private ownership of people. So, and of course, so I think, you know, there's been scholarship done about this. Pamela Brandwine has written about this, that they had a broader view of the scope of the 14th Amendment than the court has adopted in cases such as the civil rights cases in DeShaney.
I think the first duty of government is the protection of our rights. That's the only reason why that we surrender our rights to government, at least hypothetically surrender our rights to government in order to get civil rights in return that are more effective than the kinds of rights we can enforce on our own behalf in the state of nature. So if the government doesn't hold up its end of the bargain, then it's not doing the only reason for which it's been created as our servants. So that's where the protection of the law, I think, becomes the first duty of government. The problem with DeShaney in cases like this that the court is wrestling with, and there's no real clean answer to this, is that when you're talking about being able to sue the government for failure to protect and collect money damages, then those damages aren't paid by the government. Those damages are paid by innocent taxpayers. And when you open up the government to that kind of potentially unlimited civil liability from plaintiffs' lawyers, because that's who brings these lawsuits, this can bankrupt local governments so that they can't actually provide the services that they're supposed to provide. So that was the problem that the court was wrestling with. I don't know that DeShaney's the right answer to that problem, but I do know that it's a tough problem, even if you agree that the first duty of government is the protection of our rights.
Yeah, I have a question for the panel, and it's a short one.
And our time is up.
Not that short. But if you look at the structure of the 14th Amendment, you get first the definition of citizenship, then citizens get privileges and immunities. But when you're talking about both due process and equal protection, the word they use is person, which is a broader class than citizen. Now, many of you, when you talked about the incorporation from the earlier Bill of Rights, went from the Due Process Clause, which deals with person, into the Privileges and Immunities Clause that deals with citizen. So what I'd like the panel to tell me about is how it is that you cash out the difference between those two conceptions, because it seems to me you have to find something about privileges and immunities which is above and beyond the basic rights that you see in the last two parts of the clauses, and I haven't seen any hierarchy of rights in the discussion that I've heard thus far.
Another problem in textual constitutional law that would be solved by the correct reading of the Privileges or Immunities Clause.
Should I repeat that?
Citizenship has its privileges, and those privileges do extend beyond natural rights. And so there are additional privileges, like for example, Richard.
Hold on,
Judge,
the panel is
order in the
over.
court. There was a
Richard, the
danger
panel
of you
is-
actually
Judge,
answering his question.
Your Honor.
No, I don't.
Your
I
Honor.
think that's actually backwards. I think the system of natural rights is not predicated to any state. And so what happens is when you start to create a state, I think there's certain bedrock rights that everybody gets, but then there's some extra rights that citizens get because the citizen is an implicit notion of preference to the local guys as against anybody else, which is why I would love the panel to speculate about the relationship between citizenship on the one hand and sort of alienage and immigration on the other, which I think is what really raises the point in a very explicit fashion. Of course. Because we can keep aliens out plain old pronto, right?
I'll just note that Charles Black said that he was glad that the Privileges or Immunities Clause had been killed by Slaughterhouse because it was only limited to citizenship, and he preferred to have rights incorporated via the Due Process Clause because it applies to all people.
One of the things that we've been robbed as a culture by the failure of the court to take seriously the Privileges or Immunities Clause in cases like Cruikshank in the 1800s and obviously through the 20th century and 21st century is a discussion of exactly this kind of question. If the court had taken seriously this distinction in the structure and the architecture of the 14th Amendment, it would be forced to explain what the rights of citizens of the United States are and how they are distinguished from the due process rights and equal protection of the law rights that you find in the rest of Section 1. We do not have that. So we've lost many decades of a jurisprudence that likely would have developed. Now, my own guesses along these lines, and again, I'm trying to create a jurisprudence out of whole cloth, but you're probably going to be looking at provisions like the Second Amendment right to keep and bear arms that might be associated more with citizenship and not be equally granted, I didn't say denied altogether, not be equally granted to those who have not taken the oath of allegiance. But I don't know. It's going to be something that we can partially reconstruct out of history, but have not done so yet.
Here, Professor, you can use this one.
It has to be.
I would put it the following way. I think that what happens is that due process protects you against two things, incarceration on the one hand and expropriation on the other. I think that privileges and immunities for citizens give them the opportunity to work, which is not given to foreigners, and gives them the opportunity to acquire property, which similarly can be systematically designed to people when we have it. And that, so the economic liberty stuff is not given to foreigners, it's only given to citizens, and the other rights are bedrock because the essential theory of international law is not a theory of natural rights, it's a theory which tries to figure out how it is that we essentially do the relationship between ours and theirs. And I think that's the best possible distinction that I've been able to come up with to deal with it. Does that strike you as implausible, wrong, or maybe even sensible?
Is there another choice?
I don't know. Any alternative you want? I've had enough.
He pleads the fifth.
So you got to answer the multiple choice, and we'll finish up.
What was that? What are the choices? Plausible? What are the choices?
Plausible, sensible, inevitable, or crazy?
I will answer that. I will answer. I think that it is perfectly sensible. So do I. I've just never used that as my guide to understanding constitutional meaning.
Sensibleness?
For example, the idea that you could keep people as chattel slaves just does not strike me as sensible at all. And yet, nevertheless, we had a constitution properly interpreted that left that issue to the states for most of the decades of our constitution. There are many things in our constitution that would not strike me as sensible and that thankfully have been amended and removed. That's not the test. That's not the test.
But it is, in this case, there's no 3/5 clause or anything like that.
Your Honor, is this the way you run your court?
All right, so...
Thanks, Randy.
Remember, please don't leave for a moment. There's an award presentation, and thank you for already thanking this fabulous panel. As promised, you won't see anything as great as this with our keynote interaction anywhere else.